Tonight, all clear for Fix the Country street protest as Supreme Court sets aside injunction that indefinitely barred the agitating youth from hitting the streets. But the police may yet succeed in stopping the protest once more as they pursue another case at the High Court. We have details of that for you. Another story we are following for you tonight. The NDC minority in Parliament, they are making another U-turn regarding yet another ministerial nominee whose appointment they had earlier frozen. Tonight we tell you why the NDC MPs on the appointments committee say they will no longer oppose the approval of Deputy Energy Minister nominee Andy Ejapa-Mensah.
We at the Appointments Committee will not press it further, and the proper forum maybe is Privileges Committee, and there again the person needs to prove that he participated in the vote.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Gasem Cement. The Nation Builder is also brought to you by Vodafone. Remember the Fix the Country protest that the police got an order to stop? Well, organizers say they are back on track to organizing what they describe as a massive mobilization onto the streets to drive the preparation to hit this government and their concerns with issues that they believe is completely broken in this country as they term it, Fix the Country. They say on the back of the ruling today by the Supreme Court, they have all clear now to hit the streets. They have in the last few weeks agitated on social media demanding that government fixes what they call the worsening living conditions in the country. They wanted to take the online protest to the streets, but this was halted when the Ghana Police Service secured that court order. That has been set aside now, and appears they have the all clear. But we're learning, and we'll be speaking shortly with the police who say they are determined to still stop the protest from proceeding. Why? We'll learn about that shortly. Let me bring in my court correspondent, Joseph Akablay, who joins us on the telephone line right now. Give us details. You were in court today. Explain to us why the judge, why the Supreme Court agreed with the arguments put forward by the Fix the Country.
That Justice Yapo, who read the decision of the court, made was to the effect that under the High Court rules, if there is a request for an injunction and it's by ex parte, in which case the individuals you are seeking to restrain do not have the opportunity to be present in court to respond to it. Under the rules, such an injunction is supposed to last for just 10 days. And so they said it was in error that the court granted the injunction in that manner that was simply indefinite, saying that it remains in force until such a time that the restrictions on public gathering are lifted by the appropriate authority. And so that was the reason why the court agreed with the opinion of the Fix the Country protesters to the effect that that decision was in error and proceeded to set aside the portions of the court order that granted that particular relief, indicating that they were barred from engaging in any protest. Let me specifically read that portion of the order. It says, it is hereby ordered that the organizers or conveners of the Fix the Country protest march, the associate officers, agents, assigns, and workmen be prohibited from embarking on any demonstration on Sunday, 9th May 2021, or any other date until the restriction on public gathering is lifted by the appropriate authority. The Attorney General Godfrey Yeboah Adame had argued that the order was granted on May 6th and was to last 10 days. And as far as he's concerned, he said under the rules of the High Court, it couldn't have been more than 10 days, and so they should treat it as 10 days. And he told the court that, in fact, the IGP took that same view, and that is how come, even before the expiration of the 10 days, another application was filed, which he made reference to, which is pending at the High Court, seeking for, this time around, a notice to injunct them from embarking on the protest.
But there appears to be a certain difficulty that might emerge because we are learning of this subsistence of another case at the High Court that the police, we're learning, is determined to pursue that may yet stop the protest from going on?
In fact, the next hearing date for that particular case is June 14. And in the case that was filed by the Ghana Police Service, it also makes reference to the fact that the COVID-19 protocols are still in force. And so that was the case that was heard on Friday, that if you recall, the protesters, the campaigners had difficulty accessing the law court complex because of the issues that were raised. But the documents that have been filed in court, it makes reference to the fact that the Ghana Police Service is aware of the plans by the protesters to hit the street if the 10-day order, which has since elapsed, which the court has today set aside, if it elapses, the police said it has intelligence that they will go ahead with the protest. And so they've applied to the court that it will restrain them, because the Ghana Police Service holds the view that any such protest will amount to a super spreader COVID-19 event. And so the court should restrain them from going ahead. And so on June 14th, it will be argued at the High Court, where they understand the protesters will be making a strong case against this particular position that has been taken by the Ghana Police Service.
And I wonder, did you get a sense in court today when this judgment was delivered from the Fix the Country campaigners that they intend to hit the streets anytime soon?
In fact, I communicated with some of the individuals at the forefront of the whole movement, and the point they said to me when I asked whether they said they plan to hit the streets anytime soon, the response was mobilize, mobilize, mobilize. They said that is what we are doing now, and we'll hear from them in due course as to when exactly that action in terms of the street protest will come up.
Joseph, thank you very much. And we'll hear from the Fix the Country campaigners themselves very shortly. But what does this mean for the protest? Can they indeed go ahead, considering the fact that there's another case that is pending that the police is telling us tonight that they intend to pursue, and they're looking forward to be successful again in stopping them? Let me bring in paralegal practitioner to weigh the options now. Martin Kwebu joins me on the telephone line right now. Mr. Kwebu, thank you for your time here on Top Story. So I wonder, on the back of the Supreme Court verdict, can the campaigners hit the streets tomorrow if they wish to?
Evans, in the first place, I should say we should commend the Supreme Court for, coming to the ordinary citizens' rescue, right? Yes, because the Supreme Court has done it right by us, by finally settling this question that the police can't take our rights for granted, okay? Yes, so I think that we need to give all our accommodations to their losses, the justices of the Supreme Court. This is what we really bring for our country, right? Okay, so when it comes to the demonstration tomorrow, that one, it appears far more complex. And as far as actually, I think the Supreme Court's ruling is more than sufficient in terms of what is gained. It's more than even the intended demonstration. At least it has put the police at the wrong side of history. The Supreme Court has put the police at the wrong side of history, that in these matters they shouldn't rush to court alone. This kind of ambush litigation was thrown away 10 years back, and yet the police would not modernize. They still like this buga tactic. So if you ask me, look, there is no point in the demonstration anymore. The Supreme Court has made the point for the Fix the Country conveners. But if they intend to go on, the point is that I understand there is another motion pending before the High Court where the police this time round have served the convenience of the Fix the Country demonstration. So it means that I understand the next hearing is on Monday the 14th. So I think in circumstances like this, the best is to wait for the court.
But they can choose to go tomorrow.
No. Once there's a motion, so that's something from what I understand. They've been served. Actually, I think I've seen social media copies. If what I've seen is true, once the matter is before the court and the conveners have been served, it means that they have to wait for the judge to decide this matter.
So clarify for me, but they've just been served with a notice that this is happening. But they haven't ruled yet. But they've just secured a clearance from the Supreme Court. I mean, are they mandated to, or is this out of good legal practice?
No, they are mandated.
Okay.
So what I'm saying, they are mandated to wait because from what I understand, they've been served with another application by the police that the police say they've heard the conveners are about to embark on another demonstration. So the police went to court. But this time the police served them. I think the last time I saw them in court about a week or 2 weeks ago, I saw them in court and then the matter was adjourned. And the son is coming on the 14th. So once they have been to court, they have a lawyer, and they are aware that the judge is here to rule on the matter, then it means that they cannot go to court. Sorry, they cannot go on the demonstration based upon the Supreme Court judgment.
Thank you very much, Martin Kwebu. Of course, is a paralegal practitioner. I want to bring in Ernesto Yeboah, a member of the Fix the Country campaigners. Mr. Yeboah, thank you for your time here on Top Story. So what's your next move?
Evans. Before I come to that, let me use your platform to say a very big thank you to our legal team for the marvelous work done. We also want to say a very big thank you to the millions of Ghanaians who have received the message and have supported us emotionally, materially, financially. The victory is for them. We are doing this for them and for posterity. In terms of our next line of action, one word summarizes it, and that one word is mobilize, mobilize, mobilize. The work has only begun. We are building a coalition of young people in this country. We are taking charge of the destiny of this country. Since those whose responsibility it is to lead are refusing to lead. If it wasn't that, then how come simply saying fix the country makes them so angry? Why does it upset them so much to the point of using the police that should be protecting our rights, that should be protecting our interests against we the people? So one word, like I said, summarizes it. We are going to mobilize until this false, fake system falls.
Does that mean you say you mobilize? What it means is that you're mobilizing, but not a plan has been set yet and a date set for actual boots on the ground with this protest?
So we are an underground movement, and so every action we take is towards that objective of fixing the country.
Yeah, I'm just asking about the actual protest you had planned, for which reason you have fought this at the Supreme Court. Is the protest coming off, and when?
Well, like Martin, said, we certainly have to wait for the order from the court, and then, of course, on Monday we are in court. So we have to see how these two play out, and I think our legal team are on the ground looking at what actions we can take within the space given.
So you simply have to wait. But of course, nobody knows how long this is going to take until that is done. Then you fix a date for a protest. That is if you win.
Well, we are strategizing, and so we await the advice from our legal team.
That is Ernesto Yeboah. You just heard it there. They will wait, as the lawyer had suggested earlier, that they have to wait for the High Court's decision on the substantive matter that the police has filed. And police pushing this, confident, they believe, that they can still stop the protest from going ahead. And as we've heard, the police earlier had told us that they are going to pursue that other case quite vigorously with a view to stopping that protest from going ahead. And I must indicate to you that the police's arguments back at the High Court on this still relates to COVID-19, with the argument that it's a super spreader event, for which reason they're still asking the court to stop them from proceeding. Once we get more clarity on this, and we're expecting a police statement on this shortly, we'll get it to you. And so live here on Top Stories on Joy 99.7. If I want to take it to Parliament right now, because the minority members on the Appointments Committee, they've made yet another U-turn regarding another of President Akufo-Addo's appointee, whose appointment they had earlier frozen. This was just less than 24 hours ago when they decided to freeze the approval of the nomination of Deputy Energy Minister Andy Ejapa Mensah. Why did they take that position yesterday? They had expressed concerns, Mr. Mensah's insistence that the PDS ECG deal was not abrogated on fraudulent grounds, contrary to the position of the energy minister then. In fact, Ejapa Mensah had said before the committee that the former minister's position was simply untenable. They also raised concerns about Mr. Mensah's role as director of TG Solutions, which is part of the PDS consortium. And they say his role amounted to conflict of interest when he, as a member of parliament, had participated in a vote that eventually led to the approval of the PDS deal when he had not declared that particular interest. And so yesterday, just in the evening, they took a decision that they will not recommend his approval to the plenary. But in the last couple of hours, we are hearing different. The minority members have held a meeting and they have now decided that they will no longer oppose the approval of Andy Ejapa Mensah. Listen to Mahama Yarega, who had been explaining this.
Yes, we just concluded deliberations, and I think that the issues are that we in the minority had issues with him because a company in which he is a director and secretary happens to be a partner in the what's it called? PDS, firm. So when we're debating the issue in Parliament, I was not there, but we were told, and he didn't deny it, that he argued in favor of the passage of the contract without indicating that he is a director in one of the companies that was a partner in the PDS company. So our position as a minority was that that's a clear case of conflict of interest, which he ought to have disclosed, but which he did not disclose. So that was what we were holding him on. But then we went and then we had some further deliberations. Those of us who are lawyers looked at Article 104, Clause 5 of the Constitution, which I think is the operating clause that deals with this matter. And what that clause says is that a person who is a partner in a firm which is entering into a contract with the state, and that contract is a subject of consideration by Parliament, must declare his status and must not take part in the voting. Okay? Must not take part in the voting. Now, we came to a conclusion as a minority that he is a director. He is not a shareholder. Is that okay? He is a secretary. He is not a shareholder. But we still felt that he should have disclosed that interest. But then we also came to a conclusion that we in the minority walked out. We were not there when the voting took place. Because we're not there when the voting took place, we are not able to establish whether he actually participated in the voting. And also, it was a voice vote. So we're not able to establish whether he actually participated in the voice vote.
So that is Mahama Yarega there, explaining why they have decided at this moment no longer oppose Ejapa Mensah's nomination and approval on the appointments committee. They will now have to now recommend his approval to the plenary after they have withdrawn that yesterday for consent that he had raised. I want to bring in my parliamentary correspondent, Joseph Gakpo, who joins us on the telephone line. Joseph, it appears to me from listening to Ayerega that whether or not they back Evans Mensah's approval rests on evidence that may be in video on the floor of Parliament. It almost certainly saying if we can capture him participating and actually voting for the deal when he had not allegedly declared his interest, then we have a case of conflict of interest against him, and then we can be in a position to comfortably say we will not approve his nomination. But the question is, that evidence is in Parliament. As in Parliament records the videos. Did you put that question to them about will they attempt at all to verify that for themselves?
I did, and essentially the response from Mr. Ayerega was that they think that may not be necessary. In fact, in the course of the conversation, the eventual point he made was that they think these issues are not weighty enough to want to pull brakes on his appointment to the position of a deputy minister as a result of these issues having to do with whether or not there was a case of conflict of interest. Mr. Evans Mensah has been very emphatic that as far as he's concerned, when we talk about issues having interest, he said he's made the point that his understanding of his interest actually extends to whether he has shares or otherwise in PDS or in TG Energy Solutions. And so in the absence of him having any such shares, there was nothing to disclose. And he's insisting that he has absolutely no interest in whether PDS itself or the company that formed part of the consortium, that's PDS Energy Solutions, which is how come Mr. Evans Mensah says there's nothing to disclose. And from what Mr. Ayerega is explaining, a lot of them, particularly those who are lawyers in the appointment committee, appear to agree with that position, which is why they are not pushing this issue any further.
Okay, and this is also his reaction when you ask him about whether or not they'll be pursuing the evidence they may have been recorded, and also what he believes to be the next line of action once they've recommended his approval.
Well, I mean, if you bring us the videos to help us, and then we see that he actually, because this is a voice vote, it's more difficult to establish that a particular person voted or did not vote. So on the basis of those technicalities, some of the people who were holding issues with his approval came to a conclusion that the proper forum to raise this issue is Privileges Committee. Is that okay? Not at Appointments Committee. It's Privileges Committee, so that the Speaker can refer it to the Privileges Committee. I mean, the proper forum to raise it is on the floor of the House, so that the matter is referred to Privileges Committee to be investigated. And if it is established by Privileges Committee that indeed there was a breach of Clause 104(5), then you can now apply the conclusions of the Privileges Committee at the Appointments Committee.
And Joseph, did he clarify then whether or not once they've approved, recommended his approval and the plenary has accepted it, they will raise this matter formally on the floor and for the Speaker to refer to the Privileges Committee?
Himself, he makes the point that that is not something that he intends doing, except to then say that this is something that anyone else can go ahead and do if he or she thinks it's very much necessary. But as far as Mr. Ayerega is concerned, to a very large extent, they are clearing their minds on Mr. Jape's position on these issues, and as a collective, they are not fully willing to pursue this matter any further.
Okay, Joseph, thank you very much. There's more from the Appointments Committee on Newsnight, just under 4 minutes away. You want to stay with us for that. And I want to return to our earlier story now about the Fix the Country protest. They got a lifeline tonight from the Supreme Court that may have originally paved the way. But as we're hearing, the police are pursuing a substantive case back at the High Court that may stop them permanently from proceeding with that. They themselves have said they will wait for that case to be determined. I have on the telephone line right now with me the spokesperson for the Accra Regional Police, Madam Efia Tenge. Madam Tenge, thank you for your time here on Top Story.
Hello, Evans. Thank you for having me.
Great to have you. And so, what's the position of the police service on the back of the Supreme Court's verdict today?
Yes, thank you very much. As far as the Regional Police Command, the substantive case between the police and the organizers or the conveners of the Fix the Country protest is yet to be heard at the High Court, that is on the 14th of June. And so we wait for the hearing of that case at the court.
And that, just for clarity, is seeking to get the court's permission to stop the protest, and the grounds for that is, if you can clarify for us.
Yes, I think, Evans, your lead narration to my interview was a bit misleading. But it's not now that the police is seeking a restraining order against the convener. If I have to educate all of us, this case has been pending in court after the police sought an ex-party motion in court that sought to restrain the conveners of the Fix the Country protest from embarking on their demonstration. But because we went on an ex-party motion for which the court granted an injunction, we had to go back to the court this time around on notice if we were seeking to extend our restriction or the restraining order. And so that case was due for hearing on, that is a Friday, that is the 4th of June. That was last Friday. And it has been adjourned till the 14th of June, once again, for this time around, for the police, that's the prosecution unit, to state the grounds for which they earlier refused the protesters from embarking on the demonstration, and the conveners also coming forth with reasons why they think that they have the right to also go on that demonstration. And so that case is yet to be heard. What happened today at the High Court was that initially when the police sought the injunction, that is the restraining order, the lawyers for the conveners of Fix the Country protest went to the Supreme Court after we have sought that restraining order. And so when they went to the Supreme Court, they were requesting for two reliefs from the Supreme Court. First of all, quashing the restraining order which was sought by the police from the High Court, that's the Division 1, Criminal Division 1. Then secondly, also asking the Supreme Court to also restrain the Ghana Police Service from interfering in their lawful rights of demonstration. And the Supreme Court this morning, presided over by His Lordship Yao Appel, today ruled that yes, they have quashed the earlier relief, that's the first relief of the restraining order, which was the injunction. But he refused to grant them that relief of restraining the Ghana Police Service in actually interfering in their right to demonstrate. Of course, it referred all of us to the 14th substantive case that is yet to be heard at the High Court. So if anybody should go around indicating or saying that they have the relief to go, then I believe that people did not really understand. The Supreme Court actually did not even go to the sense of asking them to even go on that demonstration. That case is yet to be heard on the 14th.
And the grounds,
why would anybody go and say that the followers are ready to go?
And the grounds for that 14th hearing is still the potential for spreading of COVID, correct?
Exactly. Whatever we were doing in court, that is what still pertains. We went on the grounds of the public health. And so this time around, we went on notice. And so the conveners, through their lawyers, will this time also think they have to go on that demonstration. Then the police will also put across to the High Court why we also So now that the case will be heard.
I'm grateful. I'm grateful if you are it. That's she speaks for the Greater Accra Police in the back of that Supreme Court decision today. News Night starts right now.